All rise. The Magistrate Court of Kuantan is now in session. Honorable Magistrate Nordiana binti Abdulaziz presiding. The case before the court is the case of Pendakwa Raya against Sabariah binti Adam, criminal trial number 83RS-206-08/2016.
The accused person, Sabariah binti Adam, who is known as Sabariah, 49 years old, was charged with 2 counts of knowingly concealing stolen property, an offence under section 414 of the Penal Code. She claimed trial to both charges. Prosecution is conducted by Deputy Public Prosecutor Muhammad Shahrizad binti Ahmadan, while the accused is represented by Encik Muhammad Saifuddin bin Dato' Abdul Rahman. The charge preferred against Sabariah were as follows. The first charge, bahawa kamu pada 9 Mac 2015 jam lebih kurang 12.06 tengah hari bertempat di alamat Public Bank Jalan Berserah dalam daerah Kuantan dalam negeri Pahang Darul Makmur dengan sengaja telah membantu menyembunyikan sesuatu harta iaitu wang bernilai lebih kurang RM3,500 yang mana kamu pada masa membantu menyembunyikan harta tersebut yang berkenaan itu mempunyai sebab mempercayai bahawa harta pencurian, maka kamu dengan ini telah melakukan satu kesalahan yang boleh dihukum di bawah Seksyen 414 Kanun Keseksaan. Second charge, bahawa kamu pada 10 hari bulan 3 2015 jam lebih kurang 11.32 tengah hari hingga 11.34 tengah hari bertempat di alamat Public Bank Jalan Berserah dalam daerah Kuantan dalam negeri Pahang Darul Makmur dengan sengaja telah membantu menyembunyikan sesuatu harta iaitu wang bernilai lebih kurang RM6,000 yang mana kamu pada masa itu membantu menyembunyikan harta tersebut yang berkenaan itu mempunyai sebab mempercayai bahawa harta itu harta pencurian, maka kamu dengan ini telah melakukan satu kesalahan yang boleh dihukum di bawah Seksyen 414 Kanun Keseksaan. So, I would like to call the prosecutor for the submission.
Much obliged, Yang Arif. Yang Arif, the first issue that arises before the court now is whether the complainant was duped into depositing money into the accused bank account and the issue of whether the accused had knowledge of the offence committed. In order to further analyze these issues, I would like to call the first witness, also as the complainant, to testify few things.
Proceed.
Much obliged, Arif. Puan Normila, can you tell us how it all began?
Well, first I made a friend on Nasir. I made a friend named Nasir on Facebook. He was a pilot from Brunei. He was very hot. He was very rich. So after a while, after a year, someone called Marisa called me on my phone.
What did this Marisa want?
Marisa said she was a freight carrier agent. She said that Nasir had sent me a package and I have to bank in some money in order to take the package.
Did she say why you had to deposit the money?
Marisa said it was for customs clearance. She said because the package was undeclared cash, I have to be there to pay the fine.
So you paid her the money?
She said if I didn't pay, I could be arrested.
Okay, can you confirm that the public bank account number 68315929909 was the account you deposited the sum total of 13,000 ringgit and 500 in?
Yes, that is the account number.
Okay, no further question, Ya Arif.
Counsel for the defense, do you have anything to add?
Ya Arif, I would like to begin my first examination of this witness.
Proceed.
Much obliged, Ya Arif. Can you please introduce yourself for Nomila?
Can. My name is Nomila binti Abdullah. IC number 670125065426.
Thank you. So for Nomila, my first question would be, how would you describe your relationship with Nasi?
Well, my relationship with Nasi is very hot and very rich. So we have been communicating with each other on Facebook for about a year. So I'd say that we're more than just friends.
So would you say that you trust Nasi?
Yes, of course I trust Nasi.
Therefore, if you know and trust Nasi, you must have deposited the money into the account willingly and not fraudulently as you claim. Yes?
Yes, but
Not for the questions, Ya Arif.
but I haven't finished my statement yet.
But you have already answered my question. No further questions, yeah?
Nomila, you may step down. Prosecutor, call your next witness.
Much obliged, Ya Arif. Ya Arif, now the prosecution calls Tuan Hafri to come to the witness box to assist the argument of our case today.
Proceed.
Much obliged. Tuan Hafri, can you please introduce yourself a bit?
Of course, Yang Arif. My name is Sergeant Muhammad Hafri bin Muhammad Yusuf. I was the officer appointed to investigate the case of Puan Sabariah.
Tuan Hafri, can you please tell the court what was your findings throughout the investigation you made?
I first confirmed that through a series of 3 transactions, Puan Nomila had indeed banked in RM 13,500 ringgit into the public bank account numbered 6831592909. The account was owned by Puan Sabariah after confirmation of ownership from Public Bank itself. From here, it was quite clear that Puan Sabariah was indeed guilty. The conclusion of my investigation was the arrest of Puan Sabariah.
Okay, now can you please reconfirm the bank account number and the owner of the said bank account?
Of course. An inquiry to Public Bank shows conclusively that the bank account numbered 6831592909 is indeed owned by Puan Sabariah.
Okay, no further question, Ya Arif.
Yang Arif, I would like to start my cross-examination to witness 2.
Proceed.
Much obliged, Yang Arif. Tuan Hafi, in regards to the lodge reported by the accused, did you or did you not further investigate the said report?
No, I did not investigate the report. It was my opinion that this had been an open and shut case.
Okay, but was there any CCTV at the ATM machine?
To my knowledge, yes, there was, counsel.
So was there any CCTV footage that you obtained during the withdrawal of money?
No, unfortunately, I was unable to retrieve any CCTV footage of the withdrawal itself.
No further question, Yang Arif.
Prosecutor, do you have any witnesses?
Now I would like to request for court permission to call the accused to further clarify a few things.
Proceed.
Much obliged, Ya Arif. Puan Sabariah, do you have a public bank account?
Yes, I have one.
Okay, would you please state your public bank account number?
68315929009. It's my public bank account number.
So did you use this bank account actively?
Yes,
Okay, this bank account is registered under your name and only you will use this account without any third party. Do you agree with that?
yes, I agree.
Okay. On 9 and 10 March 2015, are you aware that a sum of money was transferred into your account?
No, I have no idea. Actually, I have mailed my ATM card and its PIN number to a man named Hussein. So I did not know any transaction occurred since then.
Okay, let me ask you another question. If an ATM card is given to another person and he or she has the PIN number, we would know that the person has access to our bank account. Is it true?
Yes,
So you did know and aware that Hussein has access to your bank account?
yes,
Okay. According to a report, you admitted receiving a call from public bank. Can you tell the court why the call was made?
yes, I did receive a call from Public Bank and they informed me that the 5,000 ringgit was withdrawn from my account.
Then did you lodge a report after receiving the information?
Why would I do so?
So I believe the answer is no. That will be all, Yarif. No further questions.
Sabariah, you may leave the stand. Defense counsel, proceed.
Young Arif, I would like to start my cross-examination of the accused.
Please continue.
Much obliged, Young Arif. Okay, my first question to you is, why did you open the account in the first place?
I was scammed by Hussein, and in my desperate attempt to get my money back, I was duped into opening this bank account.
Do you have the complete access to the registered bank account, Puan Sabariah?
No, because I mailed the ATM card and bank number to Hussein due to the fear of criminal charges against me.
How did you mail the ATM card and bank number to that person?
I sent the mail to Hussein through Post Laju.
Okay, now Puan Sabariah, can you describe your relationship with Puan Normila?
At first, I didn't know her. Only after the arrest made by the police in charge, which is Tuan Hafri, I heard her name.
So Puan, can you tell me, have you ever instructed Puan Normila to deposit the money into your bank account?
No?
So do you agree that you are also a victim like Puan Normila and not the actual perpetrator?
Yes.
What was the first action that you took after finding out about the incident?
I immediately lodged a police report.
Do you recognize these reports and can you tell me what the reports are about?
Yes. Those are the reports that I lodged to the police after I found out that a large amount of money has been transferred into my bank account.
Do you remember who was the police in charge of investigating your case?
Yes, I do. It was Inspector Magat.
Thank you. No more questions, Arif.
Young Arif, I would like to cross-examine the accused.
Proceed.
You said just now you mailed your ATM card and its PIN number to a man named Hussein to Post Laju. Is that correct?
Yes?
So is there any receipt to confirm it?
Of course, there is.
Okay, last question. You never try to trace any record on what happened to the stuff you mailed to Hussein. Is that correct?
Yes.
Okay, no further question, Ya Arif. Ya Arif, I would like to conclude my submission.
Proceed.
Much obliged, Ya Arif. Ya Arif, this is the obvious case of duping someone, or if we refer to section 414 of the Penal Code, knowingly as the offence of assisting in concealment of property. So, in order to prove the element of stolen property which come under the division referred by section 414 of the Penal Code, prosecution only needs to prove that the complainant, Normila, was duped into depositing the money into the accused Sabariah's account, and that 5 proof of actual theft is not necessary as decided in the case of PP and Zainuddin bin Ja'far. As far as knowledge is concerned, based on the circumstantial fact, the accused, as the account holder of public bank account number 683159299 has full access to the account including its PIN number. Thus, when the accused did not lodge any report or took no action to series of banking transactions in her account, the inference is that she has knowledge of the devious transaction of concealing the complainant's money and has voluntarily assisted in concealing stolen property as referring what had been decided in the case of Ahmad bin Ishaq and PP. And also in the case of PP and Song Chak Song. Therefore, I pray to the court for the accused to be sentenced to imprisonment as considering the principle of public interest that it is best served by sending the accused to prison. Reference is made to the case of PP Lu Chun Fat. That's all, Yang Arif.
Yeah, Arif, I would like to conclude my submission.
Proceed.
Much obliged, Yang Arif. Yeah, Arif, it is very clear that this is not a case of duping based on a few pieces of evidence presented that this very case lacks criminal intent. The report lodged by the accused to Inspector Megat is the evidence that there was no actus which shows her involvement in the scamming activity. As far as the mens rea is concerned, the accused has no knowledge that her account has been used for this illegal purpose. This is because the first action that she took after finding out about the incident was to lodge a police report, whereby it was still at an early prosecution stage. Besides, she has no complete access, control, and custody over the said account after sending the mail that contains an ATM card and its PIN number to the person named Hussein, and it was done due to the fear of having criminal charges against her. Therefore, it can be said that the accused is under coercion and most importantly, she is also a victim of the same crime. Lastly, in regards to the hard evidence of Exhibit P8 and IDD13, we refer to the decision in the case of Public Prosecutor and Ju Farif Ahmad Sulong. Therefore, I pray to the court for the acceptance of the document as the evidence and for the accused to have a proper conclusion in this trial despite the non-existence of Inspector Megat, the police in charge of the report lodged by the accused. That's all, Yang Arif. Thank you.
So, taken into account all the above facts presented by the prosecutor and the defense counsel, I am now at the end of my judgment. Firstly, in my view, the accused was erratic and vacillating when answering questions posed by the deputy public prosecutor. There were also certain times she contradicts herself with numerous evidence. During the trial, she told the court that she was arrested on 8 June 2016, whereas the report proved that she was arrested on 8 June 2015. Second, the accused asserted that the account number of 68315929909 public bank was controlled by Hussein as she had mailed him the ATM card and also the PIN number. The accused claimed that she was also a victim in the case of fraud committed by Hussein. However, despite her assertion, the accused present no evidence to support her claims. No banking receipt, no postage receipt, nor the details of the banking transaction to support her testimony. The non-attendance of the witnesses also affected the weight of the accused evidence, as mentioned by Edgar Joseph, J in public prosecutor, and Tan Gong Wai and another. It was held that the failure to call any particular witness is a matter which the court may take into account in assessing the weight of evidence without drawing any adverse inference, especially so when the potential witnesses were persons in respect of whom the prosecution had probably no means of knowing that they might have any relevant evidence to give until the accused himself came to give evidence. Lastly, the mens rea defense raised by the defense of counsel. The accused denied that she has mens rea to commit crime as she has no custody and control under the account, as she gave the ATM card and number PIN to a man named Hussein. However, Raja Azlan Shah delivered judgment of the court in the case of Tam Kai Yao and others, and public prosecutor held that mens rea is not something that is capable of being established by direct evidence. It could be taken from all the facts and circumstances of the case. The primary defense accused in relation to the mens rea element was that she had no possession of the ATM card as he had been posted to Hussein. Nonetheless, she cannot provide any postage receipt to confirm her defense. The truth behind the defense is so dubious. Her next defense regarding the mens rea, she claims that she completely had no knowledge of any transaction using the public bank account. However, when answering the question from the deputy public prosecutor, she contradicts herself with defense as she admitted that she had no knowledge that Hussein was accessing her account and also admitted that she was actively using the account in 2015. In the report, she also admitted that she had received a call from the public bank informing her of a withdrawal of 5,000 ringgit from her account. This shows that the bank kept the accused up to date with the transaction in the account, and in point, bank proof that the accused is aware of what is going on in the public bank account number of 683159299. The accused had not filed a report against Hussein, who claimed that she had access to her ATM card and PIN number, making her defense to be full of holes and to boot fictitious. Even though she claimed to have given Hussein her ATM card and PIN number, I would like to recapitulate my findings at the end of the prosecution case. It is assumed that the holder of the account must be held responsible for any transaction initiated or authorized by using the account number, including the transaction by another person authorized by the holder of the account. In my opinion, a mere fabrication was created in an attempt to avoid the guilt of the offense charged against her. Having said that, I am satisfied to rule on this judgment. Having considered the defense as a whole, I find that the defense did not cast a doubt on the case of the prosecution, and in the circumstances, I find that the prosecution proved the case beyond reasonable doubt. For the first and second charges, I found that the accused guilty and therefore convicted the accused of both charges. Based on the dictum, I hereby sentence the accused as follows. For the first charge, 12 months imprisonment with effect from 22 December 2017, and the second charge, 12 months of imprisonment with effects from 22 December 2017. Sentence is to run concurrently for I find that no justification ordering the sentence to run consecutively. That's all.
Good morning, I'm a 들어서면 닿을 때까지 쿨쿨쿨 잠잘 뻔 택배 아저씨 인정 소리에 기상 가까스로 부재중 전화다 소통 잠금 패턴 또 안 맞고 어제 남긴 피자 맛없어 그냥 이나 닥자 다생 세계대학변 내리쬐 아침형 인간들 진심으로 respect 불켰지 지붕킥 Please give me some 시금치 움직일 엄두도 안나 Yo 시야코 궁시렁거리는 와중에 머리꼬 나같이 피팅 중이야 주차장은 또 왜 이리 멀어 발끝에서부터 힘이 쭉 빠져 몇 주째 내비는 먹통인데다가 에어컨 바람마저 미지근하시 I wanna away 미친 하루